Did you know that a petition filed over 20 years ago could still help you get a green card today? It might sound unbelievable, but it's true, and it all comes down to something called Section 245(I) of the Immigration and Nationality Act. This law gives certain people, yes, even those who enter the U.S. without papers or overstayed a visa, the chance to apply for a green card without having to leave the country. But there's a catch: you need to be grandfathered in. And that only happens if a qualifying petition was filed for you, or for your parent or spouse, on or before April 30, 2001. Now, that date might sound like ancient history, but it still matters in 2025. For thousands of immigrants, this forgotten law remains one of the only legal ways to adjust status while staying in the U.S. So let's break it down, clearly and simply. To qualify under 245(I), two things are key. First, there needs to be a petition or labor certification that was filed on your behalf, or on behalf of your parent or spouse, before April 30, 2001. Second, if the petition was filed between January 14, 1998 and April 30, 2001, then you also need to prove that you were physically present in the U.S. on December 21, 2000 *. That doesn't mean you had to be in legal status, just that you were physically here. School records, medical bills, pay stubs, all of that can help prove it. Now, what kinds of petitions qualify? It could be a family-based petition like Form I-130, an employment-based one like I-140, a labor certification, or even a humanitarian form like I-360 for widows or abuse survivors. The petition doesn't have to be approved. It just has to have been properly filed and approvable when filed. That means it was signed, submitted on time, and based on a real relationship or job offer. Here's a fun fact. Even if that petition was withdrawn, denied, or never followed up on, it might still make you eligible today. Now let's talk money. To use 245(I), you have to pay a $1,000 penalty fee, on top of the regular green card application fees. This fee covers the fact that you're adjusting status despite being out of status or having entered without inspection. To apply, you'll need Form I-485 Supplement A, specific to 245(I), proof of your original petition, proof of physical presence if required, and all the usual green card documents, like the medical exam and affidavit of support. Now here's the part that surprises most people: your family may be eligible too. If you're adjusting status through 245(I), your spouse and unmarried children under 21 can often benefit as derivative applicants. They'll need to file at the same time, and yes, they'll each have to pay the $1,000 penalty as well. Even if they entered the U.S. without papers or overstayed, they may be protected through you. And what if your child is now over 21? It gets more complicated, but in some cases, they might still qualify under something called the Child Status Protection Act, or CSPA. That's when speaking with an experienced immigration attorney becomes essential. Now, let's clear up a few myths. Myth 1. Anyone can pay $1,000 and get a green card. No, they must have a qualifying petition filed before the deadline. Myth 2. Just living in the U.S. before 2001 is enough. Wrong. You need paperwork. A petition or labor certification had to be filed for you or your family member by that date. Myth 3. My old petition was denied, so it's useless. Not necessarily. If it was approvable when filed, it might still make you eligible. Finally, remember this. Even if you're grandfathered in under 245(I), you still need a current petition to apply today. That means an I-130 or I-140 that is active and valid. 245(I) doesn't give you a green card automatically. It gives you the chance to apply for one asterisk inside the U.S. So if your mom, dad, spouse, or employer filed something long ago, it's time to check those old records. That forgotten piece of paper could literally change your future. Talk to your family. Search your immigration history. And if there's any chance you might qualify under 245(I), speak with an immigration attorney who understands this law well. Because in 2025, this door is still open, but only for those who know how to walk through it. Thanks for watching, and if this video helped, Feel free to like, share, or drop a question in the comments below. See you next time.